Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Judicial Standards and Accountability Bill, which seeks to redress complaints against judges and bring in transparency in the judiciary. To discuss the issue, I have with me former Judge of the Supreme Court Justice S.C. Agarwal, Justice B.A. Khan, former Chief Justice of Jammu and Kashmir High Court, and former Judge of the Delhi High Court, Justice S.K. Agarwal. Now for the headlines. The Judicial Accountability Bill proposes strict code of conduct for judges. Lawyers related to judges will not be able to appear before judges. Judges will not be allowed professional work to be conducted from their official residence. Bill provides for a mechanism to probe complaints against the judges and proposes suitable disciplinary action. Appointment of judges through the collegium system, a big concern for judges. The Judicial Standards and Accountability Bill seeks to bar judges from carrying out any business, allowing family members from taking advantage of the privileges available to the judges, and provides for declaration of assets of judges and their family members. The declared assets will have to be displayed on the website of the court.
There has been several complaints against the judiciary, but Soumitra Sen's impeachment was the highlight of the ills plaguing the judiciary. Other than the provisions of impeachment in the Constitution, there is no legal framework providing for disciplinary action against judges in the event of public complaint. It is to provide for redressing complaints by public and bring it stricter accountability and transparency that the government seeks to bring in the Judicial Standards and Accountability Bill.
You don't paint the judiciary with one brush. You see, there may be a few black sheep. These are aberrations. These aberrations are so prompt and so prominent that they get spotted. And when they get spotted, they get dealt with.
The Chief Justice's conference, which had sought to lay down the judicial conduct through a resolution, was said to be not binding on the judges, because many of the judges challenged that the fact that it is binding. They said that no, this is only voluntary, this is only a model code, but not binding on us, and its breach will not result in a disciplinary action.
According to the prescribed standards in the bill, judges will have to declare assets which will be displayed on the court's website. No judge will be allowed to contest elections of a club, society or association. Judges will be barred from having close associations with individual members of the bar. Judges will not be permitted to allow any close relative of theirs to appear before them. Judges' residence will not be used by any family member for professional work. Judges will not be allowed to speculate in securities. Judges will also not be allowed to engage directly or indirectly in any business or trade except for hobbies.
The high standards of judicial accountability are, number one, complete impartiality of judges, of the judiciary. The judges are expected to be completely impartial.
The Judicial Standards and Accountability Bill will replace the Judges Inquiry Act of 1968. The bill provides for several punishments, from asking judges to step down in case of serious charges, to provision of warning to judges not facing serious charges. Under the existing law, the only option available for action against an errant member of the judiciary is impeachment. Aruna Thakur, Rajya Sabha Television.
Straight to you, sir. First, Justice S.C. Agarwal. Sir, what do you think will be the implication of the code of conducts that have been prescribed, and especially in context of autonomy of the judiciary?
I don't think it will affect the autonomy of the judiciary, but it will improve the standards, because we have seen in the past few years there has been fall in the judicial standards. Earlier there was no code of conduct, but the judge used to follow the unwritten code of conduct. But in 1997, the Supreme Court felt that some code of conduct is necessary. So therefore, the restatement of values, judicial values, was passed by way of resolution, first by the Supreme Court judges themselves, then it was adopted by the Chief Justice's Conference. But that was also not sufficient, because some judges felt that it's not binding.
Right.
So Chief Justices felt that they could not take any action in the case of violation of those standards.
Do you
Therefore,
yeah,
it has become necessary
to have?
Statutory recognition about those standards.
Sir, you've been Chief Justice of the Jammu and Kashmir High Court, and that is the most powerful, one of the most powerful positions as far as the high courts are concerned. Did you ever feel that there was a resistance from the part of the judges to follow these code of ethics, which the chief judge, the judges conference came to?
Oh yes, there has been, and there will be. This is not because that judges are not observing their own code of conduct, but this is something, some kind of a habit with the judges. They are resisting any change, and if the change is bringing a code of conduct, they will resist that also. So, but I feel that there is, much ado about nothing. We have seen generations of judges who have exercised their own code of conduct, who have made their conscience to be the conscience commission. This commission or that commission you are talking about today will make no difference unless a judge becomes answerable to his own conscience. Now you lay down 100 conditions in a code of conduct. What are the means of enforcing those conditions on a judge? If he efforts or manages or decides to be an errant judge, you can't have an army posted to watch him if he means to make a mischief. Now all therefore what is to be ensured is that a judge, it goes back to the recruitment, has to be one.
We'll come to the recruitment point, sir. That is, we have identified area for that, sir. But I would like to bring in Justice S.K. Agrawal and ask him, is this doable to clearly state so many things as if these are the things that have been going on as in the courts, to bring it and make it part of the statutes? Does it anyway affect you or your brother judges who are still in the judiciary? Doesn't it try and send out a signal that this is required, the statutory portion, and that is why we need to do this?
Speaking for myself, I am in total disagreement with my learned colleagues. Read the act as framed. It is bound to affect and erode the judicial independence, according to me. Basically, let us have a look into the history part of it that we talked. Article 124 of the Constitution itself provides that any judge who is guilty of a proven misbehavior, that judge can be impeached by the process provided under the next clause, the procedure, Article 124, subclass 5. And then we have Judges Inquiries Act itself of 1968, which have been working so well. We have in the history people who were put on the mat if they erred or they misbehaved according to their proven misbehavior. In the recent past, we have examples. I do not want to name people where they have to resign, and those who are reluctant to resign, their inquiries had to be held, and the inquiries we had, and ultimately they resigned. We had people, sitting judges of the those whom the sanction was granted for the purpose, they are being prosecuted. Therefore, to say that there was something required to be stated so vocally, forcefully, so as to make it a statutory misbehavior, which the constitutional people, constitutional authorities thought it is not necessary to define what is misbehavior, what is the judicial conduct part of it. To my mind, this act is going to be certainly is something which will affect the independence of the judiciary.
Yes, on that note, it's time for us to head into a break. When we come back, we will talk about the proposed mechanism to take disciplinary action against judges. Welcome back. You're watching Law of the Land on Rajya Sabha TV. The Judges' Standards and Accountability Bill provides for a mechanism for probing complaints against the judges. The bill proposes to set up a judicial oversight committee and a scrutiny committee to probe complaints against the judges and prescribe action against judges if they are found violating judicial standards. It's a tricky job to provide for a mechanism to probe the judges who have immense powers under the Constitution of judicial review. Keeping this fact in mind, the bill proposes to have in-camera hearing of all investigations proposed by the bill. This is being done to ensure that the judge in question does not face unwarranted defamation in the initial stage of investigation.
Judicial accountability should commensurate with judicial independence. All over the world, the practice is that the disciplinary bodies mainly consist of the judges. Actually, the UN resolution says that it should be only of judges.
The bill provides for a three-layered investigation mechanism consisting of an oversight committee, a scrutiny committee, and possibility of an inquiry committee. Complaints against judges will go to the oversight committee, consisting of a retired judge of the Supreme Court, a sitting judge of the Supreme Court, a sitting judge of the High Court, Attorney General, and an eminent person to be appointed by the President. The Oversight Committee, after determining the merit, will forward the complaints to the Judicial Scrutiny Committee. The Scrutiny Committee consists of judges of the concerned higher judiciary, which will determine if a case is made out or not. After the merit is determined in the Scrutiny Committee, the complaint will be forwarded to the Inquiry Committee. This committee, after formalizing the complaint, may initiate process of impeachment as provided in the Constitution.
It is really wrong to provide that in each High Court, the complaint will be examined by their own colleagues, so with whom they sit, they really take lunch, they meet every day. That's not a good idea.
It is felt that once the assets declared by judges are uploaded on a website, they become open to public audit and scrutiny, and any complaint arising out of it can be taken up by the Oversight Committee. In case a complaint is found frivolous, the Parliamentary Standing Committee has recommended that the proposed punishment should be up to 5 years imprisonment and fine. With Aruna Thakur, Shyam Sundar, Rajya Sabha TV. Yes, sir, Justice S.K. Agrawal, you were making a point, and that was one of the points that we need to bring out. You said that this is not really necessary because the judges, most of them are already going by this code of ethics, and there's not really a requirement to put it in the statutes. The whole point is, what impact will it have if it actually is put in the statutes?
It will, because we just cannot put it in a class-wise in that sense. For example, the misbehavior is defined. The constitutional authorities in their own wisdom thought that the misbehavior need not be defined. Today, for example, a judge goes to a party, and judge goes to a party A or party B, and whether it is a misbehavior or it is a friend's party or it is a relations party or it's, it will all depend upon. For example, the act, I'll summarize what I'm trying to say. For example, the bill itself provides, now judges will be issued, maybe issued as a measure of advisories or as a measure of, warnings. Absolutely, there will be, I have absolute doubts in the matter whether they can at all be withstand the judicial scrutiny, because there is absolutely no provision in the Constitution whereby any overseas committee has to act as a super committee to tell the judge or warn the judge, or to, some sort of a warning or some sort of a or the displeasure, etc., can be shown of this nature.
So most of the judges are not. The question to you is, most of the judges are, they prescribe to their own conscience, as Justice B.A. Khan put it. They try and toe the line. It is only a few who have such issues. In order to rein in a few, do you really think, or do you agree with what Justice S.K. Agrawal is saying? Is it going to affect the functioning of a judge if you really try and rein him? on all fours, that, and especially will it also affect your right as a citizen? Anyway you can't express your point of view on certain things, and if these things you stop doing, what exactly will you be allowed to do then?
No, you see, there are certain norms which are followed by the judges. When you become a judge, you are expected to follow certain norms.
Right.
So when this code of conduct has been levied or started, it contains most of those norms which were being followed by judges from long time. So therefore, I don't think that it will affect the working of most of the judges. It's only question arises some black sheep. They have to be dealt with, and how to deal with them.
Yes. Justice B.A. Khan, sir, what do you think? Do you agree with Justice S.K. Agrawal on the point that it may affect the personal side of the judge's life?
No, not at all. See, there has to be some kind of a mechanism for accountability of judges. You can't let it loose. It can't be free for all. And let us admit that situations have arisen where it seems to be getting out of hands at times. So there has to be some kind of a mechanism. But what should be that mechanism and how it should be evolved so that it doesn't interfere with the independence of judiciary is to be seen.
This oversight committee and scrutiny committee and inquiry committee?
See, for me, it's a patchwork. See, because this thing has been already going on if you know the inside of the judiciary. And this code of conduct or statement of values, which Justice Agrawal was talking about, made in 1997, what is that? Judges are already observing it. And some of the things to me appear to be very silly. A judge's relation can't live in his house. Now, if you have a number of judges whose wives are practicing, you have a number of judges whose sons are practicing. Now, are you going to send your wife out because you have become a judge? Or your son, an unemployed son, out, you are becoming a judge? Or your relations will not appear before you. Nobody is appearing before. Otherwise, that is our own code of conduct. Nobody has laid it down statutorily. No relation can appear. Even if he does, see, judges are on their own. If as a litigating party you tell me tomorrow that I don't want to have this case in this bench, I will say please go. Have it for whatever bench you want. No question of a relation appearing before a judge. These things are already there. Now, much this thing is made out about it that we are having a code of conduct and we are having a judicial accountability bill, so on and so forth. Mechanism is needed.
On that note, sir.
But let us debate what kind of a mechanism. Now, for example, if there is a complaint of misconduct against a judge, Chief Justice of India otherwise sets up a committee. Now, you call today it oversight committee or review committee or whatever committee.
So basically what they have done is they have taken what is already existing and tried to bring it into the statute. It's time, on that note, it's time for us to head into a break. When we come back, we will show you some thoughts of Justice J.S. Verma, Justice P.N. Bhagwati on the prevailing system of appointment of judges. Welcome back. The Judicial Accountability Bill leaves out the existing system of appointment of judges. According to the present mechanism, top 5 judges of the Supreme Court, in consultation with the Chief Justice of High Court, recommend to the government relating to judges' appointment. This system was evolved after a series of Supreme Court judgments in this regard. Former Chief Justice, Justice J.S. Verma, formalized this system. My colleague, Shyam Sundar, spoke to Justice J.S. Verma and began by asking him how the system evolved.
सेकेंड जजेस केस 1993 का मैंने लिखा था, जो कि कानून चल रहा है, इसलिए मैं ये कहना चाहूँगा उस फैसले में वही लिखा था जो प्रक्रिया चल रही थी, और ये प्रक्रिया अंदर से अपॉइंटमेंट्स में इन्वॉल्व होने की वजह से 72 में मैं जज हुआ, 98 में रिटायर हुआ, समझा, और 78 से 98 तक मैं डायरेक्टली इन्वॉल्व था अपॉइंटमेंट्स में। फर्स्ट जजेस केस भगवती साहब का 82 में आया, उसके पहले की व्यवस्था थी। फिर सेकंड जजेस केस 93 में आने तक वो फर्स्ट जजेस केस की व्यवस्था थी, और फिर उसके बाद 5 साल जब तक हम रहे 98 तो सेकंड जजेस केस की थी। पूरे दौरान में मैं इन्वॉल्व था, 2 हाई कोर्ट में चीफ जस्टिस भी रहा, समझा, लेकिन जो प्रक्रिया हम लोग फॉलो करते थे वो वही थी। जो कि पहले से आ रही थी, सेकंड जजेस केस में सिर्फ उसको फॉर्मलाइज किया गया और उसमें एरिया ऑफ नॉन अपॉइंटमेंट ऑन ग्राउंड्स ऑफ एंटीसीडेंट गवर्नमेंट को छोड़ा और यूनानिमस नहीं हो रिकमेंडेशन कॉलेजियम के तो बाहर नहीं थे, लेकिन गवर्नमेंट ने अगर अपना फंक्शन डिस्चार्ज नहीं किया और जुडिशरी ने उसका फ़ायदा उठाया तो उस फैसले से तो कोई मतलब नहीं। चूँकि फिर भी ये मेरा भी मैं मानता हूँ, लोगों का ऐसा मत है और जजेस भी सोचते हैं कि वो सेकंड जजेस केस के मुताबिक कार्रवाई जिसको अफर्म किया थर्ड जजेस केस में प्रेसिडेंशियल रेफरेंस में जो हो रही है उसमें कई खामियां लोग मानते हैं। इसलिए मैंने खुद कहा कि जुडिशल कमीशन बनाइए नेशनल, जिसमें कि न प्राइम मिनिस्टर की प्राइमेसी या वीटो पावर हो न चीफ जस्टिस की हो। वाइस प्रेसिडेंट को आप बना दीजिए चेयरमैन, जो न एग्जीक्यूटिव के हैं न जुडिशरी के हैं, वो तो कॉन्स्टिट्यूशनल अथॉरिटी प्रेसिडेंट के बाद हुआ। और प्राइम मिनिस्टर के साथ एक मिनिस्टर ऑफ जो भी हो, होम मिनिस्टर, लॉ मिनिस्टर, चीफ जस्टिस ऑफ इंडिया के साथ सीनियर दो एक जजेस जो हों वो हों, समझे, ये रहे। हाई कोर्ट के लिए चीफ जस्टिस के साथ चीफ जस्टिस ऑफ हाई कोर्ट, इधर चीफ मिनिस्टर उनके साथ हो जाए।
We also spoke to former Chief Justice P.M. Bhagwati, who had initiated the collegium system for appointment of judges. My colleague Aruna Thakur spoke to him and began by asking him about his prescription of a National Judicial Commission.
Appointment should be the Chief Justice, a senior most judge, or any other, or any two senior judges, the Attorney General, the leader of the bar, and any prominent person who commands respect among the people. They should meet together and decide upon the candidate to be appointed as a judge in the High Court and in the Supreme Court.
So two most important people who actually helped in evolve the collegium system of appointments. They themselves at times feel that this system should be done away with because it's nowhere in the constitution, in the constitutional system. How? I mean, is not in sync with the constitution. What do you say, Justice Agarwal?
You see, formerly there was a convention that the Chief Justice, before making a recommendation, would consult the two senior most judges. But many times this was not followed. So it was felt that there must some way of enforcing this, because some Chief Justices on their own, they talk to the Chief Minister and they used to make recommendations.
Okay.
So sometimes the appointments were good, sometimes they were not up to the mark. That used to happen.
Okay, that's one of the reasons why you think it should be.
So this collegium system, although it doesn't fit in with the constitutional scheme,
Right.
because the Constitution says that the Chief Justice has to alone has to send the recommendation, and this was not permissible, and it has been very severely criticized by Mr. Sirvai, the noted constitutional expert. I also feel that instead of having a collegium of 2 or 3 judges or 5 judges, it would have been better to have a consultation with all the members of the court. If all the judges are consulted by the Chief Justice and their views are taken, then recommendations are made. Then possibly they know what are the deficiencies in the recommendation about one particular judge, because other judges may know which may not come to the notice of the judge, the
Right.
Chief Justice, when he makes a recommendation.
Justice B.A. Khan feels that in case all the judges are consulted, then there'll be no...
judges agree with each other.
Okay, that's a point well taken. But administratively, you were heading the...
Yes.
One point that Justice S.C. Agarwal made was that, yes, there were appointments being made out directly in consultation with the chief ministers, and that is where the judiciary was, the role was getting affected. Did you ever feel this?
Mr. Rai, there is nothing wrong with a method or a mechanism or a system which you may lay down. It's how you work it out. Now, these two eminent judges who were talking about the collegium established by them, see, rationale of that collegium was what? That recruitment in judiciary should be left to the judges themselves, so that they ensure some kind of a fairness, and they also know what a person is worth whom they are recruiting, as against a political executive which is interfering on basis of party lines or political lines and recommends his candidate, one party recommends another candidate. That was the rationale. But these people worked it so badly out, it didn't become free from prejudice, it didn't become free from likes and dislikes, it didn't become free from wheeling and dealing, it didn't become free from any lobbying, and the result was that it's more disastrous than it was earlier.
I'll just get in, Justice S.K. Agarwal. Your thoughts on this is, I mean, see, the constitutional framework is not working out. The collegium has got its own problems. So where are we heading?
Whatever the system we evolve, it is the people who manage and run the system will matter. Whether it is a collegium system or the consultation system with the executive as a chief, with the consultation of the chief minister, if something is, if the people executing the system have some problem, it is the system, no system, however good you may make. As between the two, left to myself again, I will say collegium system would be comparatively better in the sense, maybe make it little larger. As on date, we have 3 judges plus the 2 judges of the concerned High Court, which they are required to give in writing. There, whether a particular judge is fit to be appointed to the Supreme Court or not, some changes you may add it up, but if you are completely going back to the system, which is where the politicals or the executive will be able to speak to the person concerned and the man is appointed, and there is absolutely no collegium system, probably that will be not a good day for the judiciary.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our show on the YouTube. We'll be back with a new issue, a new episode. Keep watching Raj Sabha TV.